So first, I'd like to start with the Health Care Proxy and the Living Will. So these are the two documents that we like to see our clients prepare in New York with regards to handling medical decisions. So what a healthcare proxy does is it names a person to make medical decisions for you when you cannot make them for yourself. So the healthcare proxy would name a person to make decisions along the entire continuum of care. It could be for a temporary illness. It could be for long-term healthcare reasons, and it could also be for end-of-life decisions. I do see that there's a question regarding the information pertaining to all states. Yes, all of this preparation information, it would be good no matter where you are and what state you are in. Every state is going to have a slightly different documentation, but the documents you need to prepare are the same in every state. Okay. Now, the healthcare proxy names the agent to make decisions along the entire continuum of care. When you sign a healthcare proxy, you are not giving up your rights to privacy while you are still able to make your own medical decisions. So this is not a HIPAA release. The healthcare proxy does not come into play and would not be affected until you are deemed unable to make medical decisions. So this is why it's called an advance directive. You're planning this in advance of needing it. The living will is a brief and general statement of your wishes regarding end-of-life decisions. So the most controversial decisions under the law would be end-of-life decisions. Many people will remember the Karen Ann Quinlan case in the 80s. And in that case, the courts determined that while every person is able to make their own medical decisions as they are going through any kind of medical changes, when it comes to ceasing treatment at any point in time, we would need to make sure, first of all, that the patient has reached the stage where the doctors have determined that the dying process is in place and that there is no other medical avenue to take regarding their care, and that we knew what the person would have wanted. So what a living will does is it's usually a statement regarding cessation of care at that point in time. If I am unable to make my decisions, and if the doctor determines that there is no hope and they have exhausted all avenues of treatment, then I do not wish to receive treatment. That essentially will only prolong the dying process, and that, however, usually you want to take all steps to remain pain-free. So those are the medical care documents. Now, the third advance directive that I talked about was a power of attorney. And the power of attorney is really, as I like to say, everything other than medical decisions. This is a document where you are going to name a person or people to handle financial and legal matters for you if you can't handle them for yourself. So I get the most common question I get is, well, my spouse can just do that for me. So just because you are married does not allow your spouse to act on your behalf with either a power of attorney, which you have done prior to becoming incapacitated, or a guardianship proceeding. So for everybody, the power of attorney is trying to alleviate the need for a guardianship proceeding at some point in time in the future. So if you are incapable of handling financial or legal matters, the agents that you name in your power of attorney would be able to handle those matters on behalf of you. Essentially step into your shoes and handle whatever powers you have given them in that power of attorney. We are hoping when we draft a power of attorney that we are trying to include as much as possible so that no matter what happens, 5 years from now, 20 years from now, if your power of attorney is ever needed to be used, that the powers that we need at that point in time are included in that document. If you are unable to handle financial and legal matters and you do not have a power of attorney, your loved ones, family members, or maybe people that you don't really want to handle things would be going to court to start a guardianship proceeding. And what they're asking the court to do is to have you declared incapacitated and to have someone named as the guardian in charge of your financial and legal matters. This is very expensive, time consuming. The guardian is then has to report to the court every year, which requires typically having an attorney involved for a very long period of time throughout the entire lifetime of the incapacitated person. So what the power of attorney, the beauty of the power of attorney is that you're taking the bull by the horn and making your decisions ahead of time and making sure that you put the people on there that you trust and making sure that you're giving them the ability to handle whatever is needed. So those 3 documents we do recommend for everyone 18 and over. You can't sign them under the age of 18. As a minor, your parent is in control of your personal decisions.